is in session.
You may be seated.
Chief Justice, and may it please the court, my name is Christopher Rivera, and I am representing the petitioner in this present matter. I ask for the court's time to reserve 3 minutes in rebuttal.
Yes. Okay.
Your Honors, my client stands accused of crimes punishable under the Federal Death Penalty Act of 1994. District Court, by the voice of Judge Casellas, held that under Section 9 of the Federal Relations Act, the federal death penalty is in fact locally inapplicable. Subsequently, Judge Lynch of the First Circuit reversed Judge Casellas' ruling, understanding that there was congressional intention.
We understand the procedural aspect. Why don't you just cut to the chase?
Okay, sure. Your Honors, we intend to argue that the opinion of Judge Lynch of the First Circuit was erroneous due to the fact that he relied solely on congressional intent to apply federal law that was not explicitly applied by Congress. We intend to argue and propose to the Honorable Court the adoption of the Cordova test, based
The what test?
the Cordova test, based on Cordova versus Chase Manhattan.
I didn't get that.
I'm sorry. On page 27 of my brief, you'll find our proposal of the adoption of the Cordova test, based
Cordova?
Cordova.
Cordova. Got it. Okay.
Thank you, Your Honors.
Okay.
In Cordova versus Chase Manhattan, Judge Bray explains to us that congressional intention must be based on specific evidence and a clear public policy. If it is not explicit. Senator Foraker's intention by using the local inapplicability phrase in Section 9 is precisely to use economical factors, social, economical, historical factors, and other self-government emerging considerations. Taking this in fact, we intend to argue 5 different points, to which we respectfully ask the court to ponder them one on top of the other in order to apply it to the Cordova test as stated in page 27 of my brief, in order to arrive at the conclusion that it is locally inapplicable.
So are you saying that the federal courts have to specifically look at the historical perspective of the death penalty in Puerto Rico, look at the local compact, what happened between the federal government and Puerto Rico,
Exactly.
the fact that the Constitution of Puerto Rico says that the death penalty shall not be applied or does not exist. In other words, and not just say that because it's applied to the states, it's applied to Puerto Rico or something like that.
Exactly.
You have to actually delve into the specifics.
Specifically, we're not arguing that Congress has the power to apply federal statutes to Puerto Rico, but there are limits. In Section 9, the limit is locally inapplicable. In order to take local inapplicable into consideration, I ask this Honorable Court to ponder 5 different points, of which the first one would be lack of representation of the people of Puerto Rico in Congress. Secondly, would be the nature and the compact in which the Constitution of Puerto Rico was constructed upon. Thirdly, the total inexistence of the death penalty in Puerto Rico as of Act 3. Fourthly, the historical repugnance of the people of Puerto Rico. And fifthly, the standing that my client should be afforded under the International Covenant on Civil and Political Rights. First of all, lack of representation alone, Your Honors, is a crass violation of substantive due process. And I explain myself. People of Puerto Rico have no representation whatsoever. We only have one commissioner resident who has a right to be heard, but has no right to vote. Your Honors, I think we can agree that a voice without a vote is not really a voice.
But wouldn't that be applicable to all federal laws?
No, Your Honor. The proposition of the Cordova test, as I stated in my brief, is precisely that when there is a problem of congressional intention towards the application of a federal statute towards Puerto Rico, and it is not clear on its intention, then we must interpret it under the section. This Honorable Court should interpret it under Section 9 of the Federal Relations Act. We understand that the substantive due process that is being violated of the people of Puerto Rico can be mitigated by the adoption of the proposed Cordova test, because this Honorable Court can afford the people of Puerto Rico, the U.S. citizens residing in Puerto Rico, that substantive due process that is lacking as of right now. See, the people of Puerto Rico had no say whatsoever. and the application of the Federal Death Penalty Act in Puerto Rico, and it's precisely prohibited. And not only prohibited, it's totally in existence. It is stated in our Constitution.
So basically what you're saying is that Congress has to ask permission from Puerto Rico before they can impose a federal law down there.
No, Your Honor. What I specifically mean to say is that Congress entered in a compact, and this is my second argument. Congress entered in the nature of a compact in the Constitution of Puerto Rico. The people of Puerto Rico have an expectation that the compact that was agreed upon, that specifically states that death penalty shall not exist, would be upheld.
Puerto Rico.
Of course, yes, Your Honor.
But does that give the holistic application to all of the federal statutes?
No, Your Honor. We understand that this is not the case, but we do argue that by applying the Federal Death Penalty Act in Puerto Rico without specific evidence or a clear public policy to do so, without the consent of Puerto Rico, is in violation of the very compact, which is the Constitution of Puerto Rico. You see, Your Honor, the people of Puerto Rico had an expectation that the bilateral agreement, which is the Constitution of Puerto Rico, would be upheld by both sides. You see, Your Honor, the compact has been stated by various
Isn't
U.S.
it upheld if the United States expects the government of Puerto Rico to impose the death penalty as it sees fit? Even if the United States government, under the Supremacy Clause, applies it holistically to all the citizens of the United States?
Sure, Your Honor, and we do not argue that the Supremacy Clause does not apply to Puerto Rico, but we do argue that the Supremacy Clause does not apply, that Congress cannot apply every law if it's locally inapplicable. And I explain myself. Cohen versus Virginia, Justice Marshall explains to us that Supremacy Clause, that states cannot oppose the application of federal statutes due to the fact that they are represented in Congress. People of Puerto Rico are not afforded this representation, Your Honor. So under the Constitution of Puerto Rico being a bilateral
When Puerto
compact,
Rico entered into the compact with the United States, Puerto Rico was aware that it had zero representation in the U.S. Congress. And the PRFRA states under Section 9 that all federal laws will apply to Puerto Rico except those that are locally inapplicable. When the FDPA was enacted, there was explicit language precluding the application of the statute to the American Native tribes, American Indian tribes, American Native tribes, Native American tribes. They were explicitly left out.
excluded, yes, Your Honor.
But guess what? Puerto Rico was not left out. So under the statutory construction method by Murphy, was it that who taught us? Professor Murphy. It says that expressio unius exclusio alterius. That's a Puerto Rican phrase. It means that the express inclusion of one is the exclusion of the other. But in this case, the fact that Congress explicitly kept out the American Native American tribes. Okay. Think about
You have a minute.
the rest.
Your Honor, if I may,
He went back on his word because before he told me it was a minute and a half.
All right, you can get a minute.
So
yes, Your Honor, we
Yeah.
understand that the exclusion of the Indian Americans is
Exclusion.
The exclusion, yes, is explicit and it's expressly excluded. We understand that this is a double standard, Your Honor, because the exclusion of the Indian Americans was precisely for the same reason. You see, Your Honor, Indian Americans have no representation in Congress either. Now, upon the construction of
So
statutes,
you argue equal
of
protection.
course, Your Honor,
But
they
we're
should
talking-
have
I know,
explicitly
but we're
stated.
talking about the statute right now.
Yes, sure.
If they were excluded, then if the Congress' intent was to exclude Puerto Rico, it would have. They know how to exclude. We established that, right?
Of course, Your Honor. We understand, but under the construction of, if I may finish my argument.
You may finish.
Thank you. Under the construction process, we must assume that Congress did so in accordance to its constituents. The constituents of Puerto Rico hold under Article 2, Section 7 that federal death penalty, that the death penalty will not exist in Puerto Rico. Hence, Congress, we must assume, this honorable court must assume that it did so understanding that the Constitution, that the constituents in Puerto Rico are opposed to the death penalty and cannot be arrived at the assumption that they did so wanting to include.
Okay.
Thank you, Your Honor.
Thank you.
Thank you. Sometimes they can rebut. They're confused as to-
Well, we want the ones who are going to rebut the opposite side of the appellate on that particular issue come next. Is that you?
No, we actually did not save any time for rebuttal as respondent.
No, I mean
Opposition.
the opposition's argument.
Sure.
The opposition in chief to the argument we just heard.
Okay.
We don't know who that is. You know. Is it?
Well, we're working together. We're a combo.
Oh, you together? Oh,
Okay. You ladies first.
So whoever has the argument in chief against what we just heard, then that should be the next person to.
Okay.
Right?
Your Honor,
Yeah, right.
Your Honor, petitioner mentioned the establishment of the Cordova test.
so that's you're the one, right?
Yes. Well,
You may be seated. Okay.
Your Honor, the petitioner mentioned the establishment of the Cordova test. Just to clarify, the Cordova case is non-binding, and therefore this test doesn't exist.
Why is it not binding?
It's not binding because there's ample evidence already, and we'll go into this when we go into our argument, but there's ample evidence already of how this matter should be settled. For example, we have the Ecosa Martinez case from the First Circuit, as well as more recent cases that align how both the lower courts and the appellate level are addressing this issue. So, for instance, in 2012, the Federal District Court saw a case under the defendant of Burgos Montes, where they also saw a defendant being charged under Section 1513A1B, which relates to murdering someone for retaliation for participating and cooperating with federal law enforcement. And in that case, the Attorney General also was able to authorize the federal death penalty as a potential punishment. Therefore, what we see is that there is an alignment.
What jurisdiction was that?
It was under Puerto Rico.
All right.
It was in Puerto Rico. So we see that not only at the circuit level with Ecosa Martinez in 2001, but also in subsequent cases at the lower district level, we see a consistency, and given stare decisis and the principles that this court entertains, the Cordova test would fail. Thank you.
So the other counsel is going to complete the argument against the. Yeah, ask him.
Are you? Who's? Was that? Were you the rebuttal?
Yeah, it was part of it.
Is that this is one of those circumstances under Section 9 of the PRFRA that Congress will not pass a law that is locally inapplicable to Puerto Rico. And the question is this locally inapplicable?
No, Your Honor. This law is locally applicable for several reasons. First, if we look to Mercado, the case establishes a clear default rule. As you mentioned, laws and Federalism 101 will tell us that federal laws do apply in territories. So, for example, even if we look to...
But you have a conflict.
They said Puerto Rico is not a territory, it's a commonwealth, which makes that different.
Yes, Your Honor, but if we look, for instance, to the 1976 case of Examining Board, where the case looks at this issue specifically within a different context, but I think it informs our understanding of the FDPA. There, the court focused on whether the aims of the statute that was in question would be different in Puerto Rico versus in the United States. And what we would argue is that there's a clear public policy interest from a federal level to protect civilians against heinous violent crimes. Therefore, protecting a victim in Puerto Rico is no different than protecting a victim who suffers from the same
But it
crime in the
has to
United
be
States.
done within the prescription of Section 9. And that's really the question. No one is arguing that they have the right to protect Puerto Rico from, or Puerto Rican citizens from heinous crimes. No one is arguing that. The question is, can they do this pursuant to the compact?
Yes, they can, Your Honor. If we look closely at Section 9, What Section 9 says is the statutory laws of the United States, not locally inapplicable, shall have the same force and effect in Puerto Rico and the United States.
So the key is not locally inapplicable, and they're saying that this is one of those. And in part for two reasons, because the intent of Congress was not clear as to whether it would apply to Puerto Rico, number one. And number two, that there is a constitution in Puerto Rico that abolishes, or not abolishes, but that states clearly that it shall not exist. And number three, Congress had the opportunity when the Constitution was submitted to it for approval, and they rejected certain parts of the Constitution, yet they failed to address or touch or request that, I think it's Section 7 of the Constitution,
Yes, Your Honor.
be taken out. So that's,
Your Honor,
that's the hurdle you have to overcome.
If you look at both of the statutes of 924J and 1513A1B, if we look at the Acosta-Martinez case, it expressly says that it applies to Puerto Rico. And if we're looking
Which one,
at
the
crime,
FDPA?
for victims to be compensated and to feel that their justice system is really hearing their voices.
So you're saying that death will compensate victims?
No, Your Honor. What I'm saying is that we need to apply the laws uniformly, and in order to do that across the United States and not just provide preferential treatment to certain jurisdictions, you have to be able to have that option in place.
But address Puerto Rico's constitutional provision that prohibits death sentences as juxtaposed to the federal death penalty act. How does that interact?
Your Honor, it's an issue of federal preemption. So we're looking at state
Of what?
of federal preemption.
Federal preemption.
Federalism 101, we all take it in law school, who will tell you that federal law will trump state or local law. In this case, given the importance at a national level of protecting our civilians, we need to have something like this in place, and therefore it takes it out of the box of locally inapplicable. For example, something that would kind of help in terms of seeing where the congressional intent fits and where the federal interest fits is maybe something like an analogy with what's happening with carjackings in Puerto Rico right now. As of May 2012, carjackings are included within federal jurisdiction, even though it's something that one could consider to be a local issue. Therefore, if we think about how violent crimes are moving into the federal jurisdiction, and think about the fact that there isn't a specific exclusion under the FDPA for Puerto Rico, and include that also within the idea of all of the precedent that we've had so far, the natural conclusion is that the court should uphold the application of the FDPA in Puerto Rico. Furthermore, if we look at the issue, the petitioner mentioned the ICPR. There's actually a carve-out in the ICPR for the application of the death penalty, so that issue as a whole is moot and shouldn't be considered by this court.
Thank you.
Thank you.
Thank you.
Yeah, we need to hear from everybody. Yeah. I'm sorry?
He said he's going to reserve it for the
Okay. So you dealing with the next issue?
Your Honors, I will briefly address what the opposing counsel has just mentioned. Specifically, I understand that it has been evaded. What has been evaded in her argument is that Puerto Rico is not a state. So federalism, although it does apply to Puerto Rico, there are limits, Your Honor. Section 9 provides us that limit. Locally inapplicable must be stated and must be understood that the people of Puerto Rico have no representation in Congress, and I said this before, and I do with some force, because the people of Puerto Rico are afforded no hears. They are not allowed to vote for presidents. They have no congressmen,
That's because Puerto Rico is not a state, right?
Exactly.
Now,
So,
can Puerto Rico become a state if it wants to?
oh, sure, Your Honor. But
And it just shows them not to?
well, Your Honor, to address that question in specific, I understand that it is the
That's a
people.
political question. isn't it?
Exactly.
So we're
But
not dealing with political question.
Exactly. That's exactly my point. Although that it is a political question, but are the people of Puerto Rico to be applied federal statute against their will, against their desires, just because their politicians have failed to provide an answer to that precise question? People of Puerto Rico.
But didn't they provide an answer when they excluded the Native Americans and did not exclude Puerto Rico? Wouldn't that necessarily mean that the statutes, all federal criminal statutes, apply to all citizens of the United States that aren't excluded?
Sure, Your Honor. But the problem here is that we understand and respectfully disagree with that argument.
That's okay. You can do that. This is America.
We understand, Your Honor, that Congress, given this precise political...
Mr. Chief Justice, Your Honors, just to address a number of points the petitioner just made. In the First Circuit in the United States versus Rivera-Torres, this court held that most federal legislation considered by the courts has been applicable to Puerto Rico. So the position of the petitioner that this particular statute should not apply is completely contrary to what the First Circuit has ruled in the past. Particularly, there are public policy considerations when it comes to the death penalty. When we looked at another First Circuit case dealing with maritime laws that address Puerto Rican legislation, the court held that there is a national import when considering textual analysis to interpret the intent of Congress. The death penalty is certainly something that is of national import and something that should be applied uniformly throughout our court system. Additionally, in Mercado...
By the way, nobody disagrees with you on that point. The question again is whether the attempt to do that has been done properly here when you consider Section 9 of the PRFRA.
That's correct, Your Honor. When it's unclear, when Congress's intent is unclear, the First Circuit Court held in Mercado that the default rule is that the federal rule applies. And so if there's any confusion as to the intent of Congress, the First Circuit has said that the law should apply. Additionally,
all ambiguities are in favor of the government.
Not all ambiguities, Your Honor.
You said default if it's unclear.
But the court, that's what the First Circuit held, that the default rule is that the federal rule should apply. Taking that into consideration and the public policy considerations that weigh in our favor dealing with the death penalty and protecting victims against heinous crimes, it is our position that the federal statute should apply here as well.
Excuse me, but isn't the default rule basically not taking into consideration the unique position of Puerto Rico and its constitution and its, they abolished the death penalty in 1929 in Puerto Rico. And they affirmed that and confirmed that in the Constitution that they passed in 1952. And Congress had previously approved it. So if you're saying that all federal laws apply to Puerto Rico, even if Congress did not specifically mention it under a default rule, is not considering anything having to do with the specific and unique characteristics of Puerto Rico and their relationship with the United States. Well, so how do you argue that?
Your Honor, first, the way that the government has treated Puerto Rico through jurisprudence has varied, right? In some cases, the government holds that Puerto Rico is a state and applies the same jurisprudence dealing with federal and statute superseding issues. But in other instances, the court treats Puerto Rico as a territory. And so it's our position that it's not a uniform application that Puerto Rico is treated as a state. Because it has a unique position and because it's a commonwealth, I believe that's why the First Circuit held that the default rule should be what applies to the rest of the country. And that is that the federal statute should trump the local legislation.